All right, good afternoon. This is Beth Overmo, Strategic Plan Coordinator for the State Bar of South Dakota. Welcome to those who are able to join us for our February Law for Lunch. Jason Sutton was not able to be here. He is on an airplane. So we just have a few housekeeping items for our attendees before we turn it over to our presenter. The presentation will last approximately 60 minutes. You will have the opportunity to post questions. We might not be able to get to them, but in speaking with our presenter, he will gather all of the questions that have been posted, and you can either post them to GoToWebinar or you can email them directly to me at elizabeth.overmo@sdbar.net, and I will collect them and get them to our presenter, and he can provide responses to all of them. There are two ways for you to access materials. The first is just basically if you have clicked the link and you are watching with us on your computer, you will see that they are on your screen. If you have joined us by phone and have not clicked the link for GoToWebinar, you can access the materials by going to the State Bar website. Just log in, click on Resources on the top bar tab. From there, you'll see another link to CLE materials, and you should see once you click on CLE materials that it is the first document posted in a PDF form, and you can download them from there. Once again, all lines are muted, so in order to ask a question, you will have to either use your taskbar on the right-hand side of your screen, or you will have to email them to me directly. And with that, I want to introduce our speaker for the day. Steve Bogue was raised in Parker and Canton, Dakota, and graduated from law school at the University of South Dakota. After spending 5 years practicing with the National Labor Relations Board in Minneapolis, he entered private practice. Although he practices with the law firm of McGrath North in Omaha, Nebraska, he has maintained an active practice in South Dakota ever since. He practices in all areas of employment and labor law and also is engaged in the practice of business-related immigration law. He is admitted to practice in South Dakota, Nebraska, Iowa, and Minnesota, and in a number of federal courts. And with that, I turn it over to Steve Bogue and thank him for being our presenter on this very timely topic, harassment prevention policies and procedures.
Thank you, Beth. I appreciate the introduction. Before I start, two things. I would like to thank Marilyn Treffs, who is the head of the Labor and Employment Committee of the State Bar. She has done an amazing job this year of organizing things, of following through on things, and of recruiting for the committee. So I think she's due kudos by everybody who has anything to do with that committee. The second is I committed one of the errors that I habitually commit, which is I think I prepared for a longer presentation than I am entitled to give. And so I'm not sure we can get through these slides, and I may indeed skip some of them, and I hope you'll bear with me. After having voiced my concerns about how I'm going to run over time, let me start off by a topic that isn't necessarily immediately within this topic, but which I think is timely. I don't know how many of you who are listening actually practice labor and employment law, and I don't know how many of you have handled or will handle a sexual harassment case. But if you fall into one of those categories, there is a change in the tax law as a result of the recent Tax Cuts and Jobs Act that you need to know about. And that is that Section 162 of the code has been changed effective December 22nd, so that if you are handling a sexual harassment or sexual abuse case, and if you settle that case with a non-disclosure clause or a confidential clause which prevents the parties to the settlement from talking about it, you are going to lose the deductibility of both attorney's fees and the amount paid for the settlement as a business expense. That could be called, I think, the Stormy Daniels proviso, but whatever its origin, if you are going to engage in a settlement agreement of, again, a case involving sexual harassment, it doesn't look like straight sexual discrimination will be involved or sexual abuse. Be aware of the changes of that section. At one point, if you didn't have a non-disclosure clause, I think you would have been subject to malpractice. I think now, if you include it, you might be subject to malpractice. But keep in mind that your client may be willing to stand by that tax treatment or non-treatment of the amounts involved if they want badly enough to keep a sexual discrimination case or sexual harassment case, confidential. That having been said, I think this topic is a fairly timely one for the reasons that are indicated in this first slide. I'm not going to go through those cases in any detail. I think you know about them. I put this slide and then the next one together for a very specific reason. Number one, these are quotes from the New York Times which relate to those two cases. And the last sentence in each one of these quotes contains assertions that I have heard from various plaintiffs' lawyers. In other words, yeah, great, you had this great policy, but the question is why, when you got earlier complaints, they resulted in no apparent discipline. Similarly, they will characterize any investigation that you do as merely an opportunity to try to shield the company from liability. And the reason I wanted to put these quotes up is that those are accusations that may be thrown at your clients, and I'm going to assume that all of you are going to represent a company at one time or another, even those who are inveterate plaintiffs' lawyers. Prepare and pursue your investigation so as to be able to answer these two accusations. The laws that are involved are fairly straightforward. I'm not going to comment on this slide. I will throw a comment in, though, that I think is significant. If you're subject to a local city or county, that is, human rights ordinance or human relations ordinance, be aware that you can opt out of the coverage of the local commissions and opt into the South Dakota Department of Labor. I think the statute involved is, and I don't have it in front of me, it's either 12-20 or 20-12. But you have to make that opt-out within 15 days after you receive notice of the charge being filed. The only thing that's noteworthy is with the federal law, you have to have a minimum of 15 employees. With South Dakota State and most of the local ordinances I've seen, you only have to have one employee before you will be subject to their jurisdiction. The damages that are available in these cases, pretty straightforward. Back pay, front pay versus reinstatement. In a lot of sexual harassment cases where the employee is no longer with the company, it simply isn't feasible to reinstate them, so the judge will have the option of awarding front pay instead. Compensatory pain and suffering, punitive damages, and attorney's fees. Be aware that if you do not prevail when you litigate one of these cases, your client gets to pay your fees and your client gets to pay their fees as well. There is, however, a limit in federal law on the maximum compensatory and punitive damages that can be awarded, and I have that in this slide. There isn't any need to comment on it. Please note, under South Dakota state law, there are no such caps, and be aware of the administrative procedure if you're a plaintiff's lawyer that you need to go through, or if you're a management lawyer that the other side needs to go through before they can get into court. And generally that will be a right to sue letter, either from the EEOC or the equivalent letter from the South Dakota State Department of Labor. The first question, obviously a big one, is what is prohibited harassment? But I want to enlarge this a little bit to take it past just sexual harassment. Because when I talk about a lot of the liability that we're going to be discussing today, or in specific, the policy that I would urge you to think about having your clients adopt, I think it would be wise on your part if you enlarged it so that it didn't just pertain to harassment on the basis of sex. There are a number of other protected statuses, I don't know, which would be subject to the same principles. And I think if you draw your policy and your complaint procedure, you should draw it up broadly enough so that it covers these other issues. One of the main reasons you're going to have a policy or recommend one is so that you hear about what the troubles might exist in your company or your client's company before a charge is filed, before someone gets on the witness stand. So again, I think you ought to broaden it. I put up the federally protected classes, the 2 South Dakota additional classes that are involved, and there are more classes such as the GINA categories that could be added as well. All of them can be the basis for harassment. I've seen cases involving each and every one of those alleged as the basis of harassment. All of them will involve unwelcome conduct because of a protected class as listed that is severe or pervasive, not and, or pervasive. If you do any research or reading of cases, you may run into some confusion because before the mid-'80s, The two types of harassment that were designated by the courts were the quid pro quo and the hostile work environment. What the new court decisions are saying is that those categories are of very limited utility. But I wanted to put them on the table because I have seen a lot of confusion from lawyers who don't practice in this area a lot about whether they still need to be worried about whether a category of conduct falls into the quid pro quo or hostile work environment. The only use of these two categories is that if it's quid pro quo, in other words, if a supervisor is saying, if you do this for me, I'll do this for your career, it'll be subject to the laws about supervisory liability that we're going to talk about. So I think you can sort of cross that off the list of terms that you need to know about. Hostile work environment is still something you're going to have to pay attention to and still something you're going to use. Again, if you run into that terminology, I think you can discard it. The next slide just describes a little more what quid pro quo is. I left this slide in the presentation despite my recent or my immediately preceding comment because the phrase tangible employment action is going to be used throughout the presentation. And that generally involves an action by a supervisor against an employee, which involves monetary loss or a negative change in their job. And we will get back into that just a little bit later. Again, it's always going to involve supervisory harassment. Hostile work environment, still a very important concept. There are no bright lines in this category. It's going to be fact specific. It's going to be decided by the facts of your particular case. It involves unwelcome conduct. It's important to keep that in mind because the plaintiff is going to have to establish it to be unwelcome. That's going to be fairly easy for them to do in most cases. But there are going to be some cases where there may be a give and take on certain joking topics, so-called joking topics. I don't believe there is a true joke that you can use in the workplace involving sex anymore. And in some cases, the plaintiff's complaint can be attacked rather on the basis of the fact that the conduct directed toward them, since there was a give and take, was not unwelcome. Speech or conduct that's severe or pervasive enough to create an abusive or hostile work environment. And the third bullet is important, conduct that has the effect of unreasonably interfering with the person's work performance by creating an intimidating, hostile, or offensive working environment. Again, based on one of those categories. There is no such thing as an independent, hostile working environment that can be litigated. It always has to be related back to a protected category. This is the balancing act. Against what constitutes a hostile working environment, the courts have said time and time again, I've cited two of the cases that are involved, that Title VII is not a civility code. It doesn't prohibit all verbal and physical harassment in the workplace, and that's a surprise to a lot of people. But I would caution you, don't use that when you're advising your client. It's not a good idea to say to them, well, you know, yeah, a lot of sexual stuff happens in the workplace, but don't worry about it because Title VII is not a civility code. I think you can use that in your defense. I wouldn't use that in the course of giving a client advice on what they can do and what they can't do. This is virtually a direct quote from the on-call case, on-call or on-collie. There are different versions of the pronunciation of that. It's something you can use in your position statement that you direct to the South Dakota Department of Labor or the EEOC. But again, don't take too much solace in that. It's a balancing factor. It's a factor the Eighth Circuit has cited to fairly often, but it doesn't end the discussion or the argument. Harassment examples, some of this stuff is pretty easy. Unwelcome sexual advances, requests for sexual favors, and more I'm seeing harassment cases that are based upon non-sexual conduct because of the victim's sex. As an example, a woman who's a carpenter, and there aren't a lot of women who are carpenters. A woman who's a taxi driver, and there aren't a lot of female taxi drivers. So there may be non-sexual conduct that's directed at them. It's not necessarily involving sexual advances or sexual favors, but it's because of their sex. So a pervasive atmosphere in these situations still can be actionable. With respect to harassment, the harasser obviously can be a supervisor. That's pretty common. It can be a non-employee. Be aware that your client not only has the obligation to make the workplace a safe one with respect to conduct by supervisors and coworkers, but also non-employees. And I've run across a number of cases involving hospitals. And sometimes the healthcare provider involved may be a significant feeder to that hospital. And they may, I mean, this happened to the wife of one of my partners, ask a nurse for a back rub because they've just had a bad day. You have a duty, your client has a duty to protect your employees from that sort of conduct, even though it's a non-employee, a customer, a client, or just a general visitor. The victim doesn't have to be the member of the opposite sex. And I'm seeing more and more cases involving same-sex harassment. And it sort of gives some life to the old statement that sex and sexual harassment generally isn't necessarily about sex, it's about power and who's in power. The victim does not have to be the person harassed. It can be anyone affected by the conduct, anybody who's witnessed it. And they can say, yeah, I saw touching that was unwelcome on a regular basis. I saw it every day, and that got to the point where I simply couldn't go back to the workplace. They may be able to establish a constructive discharge. In other words, that the workplace was made so intolerable they had no choice but to discharge. So a victim can be other than those actually involved. Unlawful sexual harassment may occur without economic injury to or discipline or discharge of the victim. That again can constitute a harassing workplace, a harassing work environment, a hostile work environment. These are examples of items or of actions that can be considered to be sexual harassment. I'm not trying to trivialize any of these actions by listing them. And you can read all of these and say, yeah, that's obvious. One of the things I'd sort of like to do is give you help in teaching the teacher so that when you give training at your client's facility, you can go through some of these examples and sort of sensitize the client to things that can happen. For example, giving hugs, massages, or neck rubs. I can't tell you how many times I have heard a client say when I'm doing training, oh, they're just a toucher. They just do that. They're just a toucher. And indeed, in one case I remember, the person who they described as I just have touched my arm virtually every time he talked to me. He was a toucher. We had to have a sidebar conversation about whether that could continue. So I think this is all conduct which I think is fairly obvious, and I'm not going to spend a lot of time going through them. The same with the next slide, verbal harassment. These are fairly good examples. One thing I would remark upon with respect to the differentiation of the law from the time that I was in law school is that in freshman torts in law school, I remember a case involving the right of privacy in which a male had gone to the home of a female coworker on 31 separate cases to solicit sexual intercourse. And the judge dismissed the cause of action, saying that there's no harm in asking. And fortunately, the law has progressed past that, and I think most of the judiciary has progressed past that. And I throw that in, again, not to trivialize any of these actions, but just to indicate how far the law has moved in the course of 30 or 40 years. So not a good idea. Pay attention to sexual jokes. Dissuade in the strongest terms possible your client from telling any sexually related jokes or putting up with any sexually related jokes. I find these in virtually every case involving a hostile work environment. Rarely are they funny when the employee who heard that joke or was subject to that joke is telling it on the witness stand. And I have yet to see a jury that cracks up when they have a sexually based joke that is repeated by a witness who is alleging sexual harassment. Nonverbal harassment, cited in a lot of cases. Let me skip to the last two bullets. Circulating offensive graphic material, email. I've been in this business a long time, and I think I've seen a lot of cases. I never cease to be amazed by the number of statements that are put into email, which I am sure would never be made face-to-face to another employee. I have at least half a dozen, maybe closer to a dozen now, cases where someone in management or a supervisor solicited sexual intercourse through an email. Now, most computers, and I think this keyboard I'm looking at, have a button called print or print screen. People seem to forget that. So one of the things you need to put in your policy if you write it up for your client is to avoid the use of email for any sexually related topics. And I'm not saying that you encourage them to proposition someone verbally or instead of in writing, but they need to be sensitized to the fact that when these emails are brought forward, again, rarely are they found to be cute. Rarely are they found to be a good joke. Circulating offensive graphic material. I've had a number of cases where a supervisor or manager has pulled up a pornographic image, put it on their screen, and called a female subordinate in, and not really mentioned it directly or pointed to it, but it's right there over their shoulder just to see what the woman would do. Again, I think they have to be sensitized to that sort of conduct, and that's the basic reason I threw this in. The third bullet, sexual and derogatory messages, coffee mugs, hats, clothing. I won't give you any examples here, but I think you can make them up. You can come up with examples from your own experience of those sorts of situations. Again, maybe marginally funny at the time, not funny down the road. Okay, let's get into what harassment is. It has a subjective component. It has an objective component. The subjective is rarely going to be a problem with a plaintiff. Simply by stating that they didn't like it, they are going to probably establish that. And even if there are situations where there has been a jocular back and forth, I think there are a lot of situations in which women have felt that they have to take the joke. And I don't think, because of the recent things involving Weinstein and the others, that women feel that they have to take the joke anymore. And not just women. I'm talking about male victims too, and transgender victims, those sorts of things. There was a pervasive view in the workplace, again, that these things had to be put up with. They don't. But what I'm telling you is that even if there was that back and forth, I think all the female plaintiff is going to have to say, or the male plaintiff is, yeah, I laughed at it. I thought I had to. I thought my job was in danger. So you're not going to be able to mount a very effective attack based on the subjective nature of the feeling that it was unwelcome sexual harassment. Objective basis, it'll be judged from the perspective of a reasonable person in the plaintiff's position, considering all the circumstances, such as the authority of the person who's doing the harassing over the job future of the victim. Again, I included this. Title VII is not intended to establish a general civility code, but take this very seriously and be careful with how you use that particular principle of the law. Okay, let's get into harassment liability. Same-sex, well, excuse me, I jumped over the policy. Okay. Same-sex harassment may be motivated by sexual desire or general hostility to the presence of the members of that sex in the workplace. You may get into a situation there where you have to litigate intent. I don't see a lot of sexual harassment cases based upon general hostility to the presence of members in the workplace. Same sex, yes, not the opposite sex, but nonetheless, it's a theory that can be alleged. Okay, let me get to the slide that I thought I was getting to. The first question you have to ask yourself, if you get a call from the client and they say, classic statement, I think I may have a problem, tell me what you think. And then they describe an action of sexual harassment by one employee, usually in South Dakota, Nebraska, in our vicinity, a male against a female. You have to find out whether the alleged harasser is a supervisor as opposed to people in any other category. The reason for that is there are very specific rules for determining liability where a supervisor is involved. For example, the next question you have to ask, step 2, is what happened to the alleged victim? If there is tangible action that accompanied or related to the sexual harassment by the supervisor, and a tangible action, again, is a significant adverse change in the employee status. Examples are up there on the slide. I needn't go through them. There is strict liability. Your client's liable. There is no shouting about it. The question is going to be how much your client has to pay. So that's the first thing you want to ask. Okay, what happened? Is there any possibility that the employee's job or some term or condition of her employment, usually it's going to be a her, was involved? Because again, there's strict liability. Second, if you find that there was no tangible action, it was a non-tangible action, then there is an affirmative defense which your client can assert. However, there will be liability unless the company used reasonable care to prevent and to promptly correct any harassing behavior. And the second part of it is, the employee unreasonably failed to take advantage of those preventive and corrective measures. What does this mean? Those are great tests, but in practicality, what does it mean? It means that your client should have a well-written non-discrimination policy, and that policy should include a very simple, a very easy complaint procedure that allows the employee to present their claim to the employer. If you have such a policy, and if the employee has unreasonably failed to take advantage of it, then you can establish the affirmative defense that's found in two cases, the Eller defense, we're going to come back to this later, or the Farragher defense, and I've cited to those cases in the second to last slide in this presentation. So that's the reason your client, if they come to you ahead of time and give you their handbook or ask you what they can do to get out from under a sexual harassment claim, you ought to be talking about. There is a third test that we can talk about in a moment, but before we do that, what is a supervisor? Who is a supervisor? The Vance case answered that, 2013 Supreme Court case. Supervisors are not those that are described in the definition of a supervisor in the National Labor Relations Act. Section 211 of the Act has a very specific list of responsibilities which can create supervisory status. This is separate and apart from it. A supervisor is one who has the authority to take tangible employment action against employees. This includes the authority to fire, hire, promote, reassign, or the authority to significantly give them significantly different duties. The authority to delegate job assignments to assign work doesn't necessarily make the employee a supervisor under Title VII. The test for coworkers, visitors, clients, customers is a fairly straightforward one, and that's why you have to ask these questions on the front end. You have to be able to ask or to tell your client what tests are involved and to ask the appropriate questions to get the information you need to defend the case. The test for coworker liability, coworker harassment, will depend upon whether the employer had knowledge of the activity. That's again why you want a complaint procedure in place, and where the employer did not act properly. Acting properly includes investigating promptly. When you get knowledge of it, I don't think it should be any more than 2 weeks. I think that based upon the cases I've read, my own experience, it should be at least a week. You ought to at least start it out. And the employer did not remedy the conduct. And we'll talk about that in a while, but you're going to have to take remedial action as a result of your investigation if you find that there's reason to believe the harassment took place, or even if you have concluded that it didn't. And this will have to do by and large to the role of policies and training. How do you get knowledge of complaints of harassment? There are a lot of different ways to get that knowledge. I'm not going to go through these slides in great detail because I think it is fairly straightforward. If you get written or verbal communication from an employee, that's pretty easy. If the employee verbally states that he, she has been treated badly or unfairly, have your client ask the question. It's not a good idea to let that question go or that comment go unanswered or unresponded to. If a third party reports, hey, I didn't have anything happen to me, but you know, I saw Joe out on the floor and I saw him touch Alice, and there's something wrong there. Jump on it. You may get confidential complaints. We're going to talk about that in a little while. That may be the source of information you have about what constitutes a complaint. And the next slide has to do with that too. Harder to recognize. The employee walks off the job, says he's fed up with this crap. This comes from a case that I worked on. I had real concerns about whether my client's failure to follow up on that, because the client later said and was prepared to testify, we settled the case, that by that he meant that the sexual harassment that was being engaged in by the supervisor, who was a guy, by the way, he had a personal feud with, he felt that was inappropriate and walked off the job. Offhand comments made, general third-party reports, not per se information, but something that you should consider following up on. This is maybe out of place in this series of slides. If you are talking to your clients, supervisors, or managers, give them this checklist of things they need to do. And I put the third box in there for a very specific reason. It is extraordinary to me how many cases could have been headed off early on in the procedure if a supervisor thought enough about a complaint made to them to bring it to the attention of management or HR. It doesn't happen in a lot of cases. When you do your training, it is something that I think you need to emphasize very, very strongly. How do you prevent harassment? We talked about this a little bit. Your client, your employer, and you, if you run a law office, have a duty to create a safe working environment. I have seen a couple of OSHA cases involving sexual harassment, but generally that's only as a subset of a larger case, and I haven't seen a lot of litigate on that particular issue. Tell your client to monitor the physical facility. What am I talking about? Graffiti. Have them monitor areas where graffiti is found. The men's restroom is a primary place where it's found. Sometimes the women's restroom. Have the maintenance staff monitor those, have them fill out forms when they find graffiti, and have them fill out a job form which your maintenance department will complete when they paint over the graffiti or remove it. Big source of evidence of sexual harassment. A policy prohibiting sexual harassment, we'll talk about that a little later. Properly and regularly trained supervisors and managers, executives, and employees. I cannot tell you how important this is. In a recent, fairly significant sexual harassment case I was working on in the southeast part of the country, more than half of every deposition we took was devoted to what the training program was, how perfunctory it was, whether anybody paid any attention to it, what they did with the materials after the training. And in this case, one of the employees testified the training was given in a monotone. They just read from it. They didn't even look up at the employees. No one paid any attention to it. They were laughing. They were making cat calls at the person who was giving the training. And although they were given written materials, they all threw them away on the way out of the room. So again, pay attention to training. Again, we'll talk about that in a second. Investigate quickly, decisively, and thoroughly. Take appropriate action. Maintain confidentiality as much as is practicable. And that is sort of hedging it a little bit. The purpose of the harassment policy, be straightforward. The first two are good: to protect the employer and discourage harassment, to encourage prompt reporting, to protect the employee against unreported complaints, and to avoid strict liability for a tangible action. In other words, when something comes up that may constitute a tangible action, it's likely going to be preceded by some comment directed toward the employee. If you can find out what that comment is and deal with the supervisor before they make a threat against the job, that's a very big check in your client's favor. Okay, if you have a policy, the policy must be effective. And what I mean, and these are just the general goals, a policy will not be effective if managers aren't trained on complaint procedures or reporting, they ignore complaints, and where there's a failure in the past to conduct meaningful investigations, where there's been demeaning treatment of past complaints, or where management otherwise discourages the use of complaints. That's in general terms. Now, the next several slides, I'm not going to go into in great detail. These are the elements the EEOC believes an effective harassment policy must conclude. And that comes from proposed EEOC enforcement guidance, as you note on the bottom of the slide, on unlawful harassment that was issued in 2017. It's about 60 pages. Comments were supposed to be submitted by the end of February. These aren't going to be controlling. In other words, if your client has a policy and they don't have all these elements in it, it isn't going to make the policy ineffective. But it's a good way to look at what the EEOC thinks ought to be in it. One thing, let me get back to something about this. The last bullet on this slide is important. Let me posit to you a scenario that you ought to be aware of. An employee comes up to a supervisor or to the HR person, and they say, I have something I want to tell you, but this is really confidential. Will you keep it confidential? And your supervisor, being no fool, says, well, sure, you can tell me anything. And then they proceed to describe in great deal sexual harassment. Do you have to protect the confidentiality of this witness or what they told you? I'm here to tell you, you can't. Might that cause a lack of communication with that employee in the future? Yeah. But if there's sexual harassment in your client's workplace or in your office, that is a corporate, that is a company problem, not an individual problem. And in my mind, sexual harassment is like cockroaches in the kitchen. If you see one, you've got 100 of them. And if there's one instance of sexual harassment, there's probably a dozen out there. So don't let your client or any of the supervisors think that because they have agreed to confidentiality on the front end, they can keep it. They can't. Again, it's a corporate policy and is something that they have to carry through on. So in the next slide here, the second statement down, confidential to the extent possible. Okay. The last part of it, your policy, and this does deserve some attention, has to include an assurance that there'll be no retaliation for any reports of sexual harassment. The policy, again, one of the previous statements that was made, is that it ought to encourage employees to report their harassment, whether they're sure it's harassment or not. Again, I'm going to go through this. Drop the legalese. Don't let the policy be written with a heretofore or notwithstanding or anything of the sort. There are going to be a lot of people that this policy should be given to who may not understand it or who are going to be put off by that particular language. And again, make sure that the policy is related to the type of work being done at this particular facility. Harassment reporting, this is an important aspect of it. A lot of companies have begun to use a 1-800 number if there are several different company facilities scattered around the country. Some of them do it internally. There are a number of companies out there that will monitor the 1-800 complaints externally. And your client's employees can use that system to report complaints. Empower in your policy the use of any supervisor or manager for complaints. Have a leap over. Have something in your policy that says, if you believe that you cannot report this policy to your supervisor or manager, or if it involves the conduct of your supervisor or manager, you may proceed directly to HR or to corporate executives. Communicate that reporting policy over and over again. In your written policies, in postings in the lunchroom, I've had a number of cases in which employees have said, they may have another policy, they may have a good policy, they never told us about it, I didn't think that anyone would listen to me. Those sometimes come in the same conversations where someone says, yeah, I did report it, but nothing was ever done about it. So again, consider the reporting technique or style you want to recommend. It should be one which is appropriate to your client's business, very important aspect of it. Harassment training, I've talked about that a little bit. Second bullet may be the subject of intensive discovery. The other side will want copies of your materials. They'll want the sign-up sheets. They'll want tests, if tests were administered at the end of training. A lot of companies do that to prove that the employee was involved with it. I am not a big fan necessarily of videos or computer programs. They're out there, they can be used, and if you don't have anybody in your client's hierarchy who can administer the training, you have to be pragmatic about it. You may have to use it. It's going to be better than nothing. My druthers would be in the third bullet there, that you use some sort of interactive training. There's some give and take so that you can prove that the employee was involved in the procedure. It should be properly documented, very important. I think you want to go back to it. You want to be able to prove that you did it. Again, you want to improve that, or be able to prove that employees were involved. If you can have the CEO or their owner start out the training by coming into the room and telling employees how important they think it is, that's great. Get senior leadership to buy into it. Get all levels of leadership to take part in it. The training should be repeated. You're going to have new people in. You can train them during your probationary, your break-in period, or you can go through the training every year or 2 years. It must be repeated. It has to be provided to employees at every level and every location. Think about providing it in all language commonly used by employees. Important, tailor it to the specific workplace and the workforce that is involved. The training should include description of what constitutes harassment, examples of harassment, not in particularly graphic detail. I think you can be generalized there. An explanation and emphasis on the complaint process, and provide an explanation of the possible consequences of the harassment. This should all be in the training. You need to give supervisors information about how to prevent, identify, stop, and report and correct harassment. I can't emphasize how important that is, and I'll repeat myself because at a certain point that's just about all I do. Sensitize your supervisors of the importance of reporting conduct up the chain of command, even if they're not sure that the conduct is unlawful conduct. Even if it's conduct that looks suspicious, but they can't really say it was harassing, the company needs to know about it. The company needs to make the decision about whether to investigate it, not that supervisor. That should not be part of their job. They shouldn't be the final decision makers in these situations. And include an explanation of the consequences of failure to fulfill the responsibilities related to harassment, retaliation, or other protected conduct. I'm actually getting through this a little more quickly than I thought I would. You may be called upon to engage in an investigation of the harassment. And before you do that, number one, the investigation is obviously extremely important. You need to find out who took part in the alleged harassment. A lot of the high-profile harassment cases, which involve a lot of different allegations of harassment, will focus on the training, on the handling of complaints as an important part of the investigation. That's something you need to take a look at. You need to decide who is going to be involved in the investigation. If it's a high-level supervisor or manager, you may need to use outside investigators. I'll jump ahead. At the end of your investigation, you need to reach a conclusion. That seems very obvious. I've seen investigations where they just seem to sort of go off into the sunset or something. You need to take action reasonably calculated to end or prevent further occurrences of harassment. Let me emphasize that. You do not have to, as a result of every claim of sexual harassment, terminate or discipline someone. I was in a sexual harassment presentation that the Nebraska Bar Association gave a long time ago, and a question was asked from the audience, what if we can't come to a conclusion about whether there was merit to the sexual harassment complaint? And the presenter said, that's easy. If the alleged harasser was a male, fire him. Juries are much less likely to hand down damages against the company if it was a male involved. That came down days before a case involving, I think it was the Miller Brewing Company in Milwaukee, where an employer terminated a supervisor because he engaged in an off-color joke. It was a joke that was involved with a Seinfeld show. I won't go through it. They fired the guy for it, even though the investigation didn't really indicate that it was harassment. And a jury handed down an award of $21.7 million against the company. So again, concentrate on what you need to do to prevent future occurrences of harassment, not necessarily always disciplinary action. Then always, 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 that's 4 alwayses, report back to the employee. You don't have to tell them of what you have done or the specific discipline you've imposed, if any. That's a private concern between you and the other employee. But get back to them and say, oh, we appreciate your coming forward. Please do so if further activities occur. We have taken steps to make sure this activity doesn't occur in the future. Come back to us if it does. And again, I put the note in there to emphasize the importance of that particular aspect of it. What are some of the examples of response and remedial action which have been accepted by the courts? There's a list there. Bullet number 3, never ever transfer the victim unless the victim wants to be transferred. That's not their problem. If they want to be away from it, if it's what they characterize as, and I hate this phrase, a good old boys club, they may want to get out of there. If that's the case, you can't tell them no, by golly, you're going to stay there and put up with it. But I would not knee-jerk a transfer of the harasser. Excuse me, let me restate that. Transfer or reassignment of the harasser, not the harassee, not the victim. Special counselings, oral or written warnings, apology by the harasser to the complainant. Rarely will the complainant be terribly impressed with that. They're going to see it as a sort of a gun to the temple type of an action. Nonetheless, it's not bad in certain instances. There may be retraining. You may want to reissue the employer's sexual harassment policy. I've begun to do that in a lot of cases because it gives you the opportunity to engage in further training even on a micro basis. It can be a general admonition letter to the alleged harasser. What I mean by that is a letter that says, you have been accused of engaging in sexual harassment, and this is not the best verbiage. We have conducted an investigation. We've been unable to determine whether sexual harassment took place. Attached to this letter is a copy of the employer's sexual harassment policy. We are going to have you sign a receipt for that policy. If in the future any activity such as that you have been accused of is to occur, you will be subject to a discipline up to and including discharge. You don't necessarily need to put that in their file. You can put it in their file, but it gives you an example of something you can do that is lesser than final discipline, termination. This is something I started to touch on up front. In the investigation, you will need to determine which person should be the investigator. It's going to depend upon the nature and the intent of the allegation. More widespread allegations may need someone from outside the company. It's going to depend upon the level of the alleged harasser. You're going to have to determine whether you want to use an internal investigator versus corporate counsel. I don't ever think it's a good idea for corporate counsel to get involved in this investigation. I think it's an excellent idea to have corporate counsel involved in the management or the plotting the course of the investigation, but you don't want to make yourself into a witness, and you don't want anybody in your firm to be a witness. And just about every investigation that you're going to conduct in the workplace, or the employer is going to conduct in the workplace, has the potential of being used as part of your client's defense in litigation. So again, don't let external counsel, and if corporate counsel wants to be involved, fine. But keep in mind that they're going to, again, probably be a witness. The thing I don't like about the corporate counsel aspect of it goes back to the very first slides that we flipped up on the screen about it was an internal investigation to shield them from liability. If it's a widespread situation, think about using an external attorney, maybe on a one-time basis, someone who has some experience in it. Robert Mueller's busy right now, don't be calling him, but it can be someone else who has experience in these areas. And then prep them on the fact that they could be used as a witness. They're going to have to testify about the good, the bad, and the ugly, obviously. The role of corporate counsel and outside counsel is going to be the direction of the investigation, and I want to talk about that in just a moment. As a matter of fact, the next slide. And keeping track of it, find out how far it's going, keeping track of the investigators, particularly if they're lay people, HR people from inside the corporate entity, and making sure it goes in the right direction. If materials are prepared, you can try to cloak them in the attorney-client privilege by giving directions to the investigator that you need them to investigate certain allegations in potential or preparation for potential litigation. That's wonderful. It might establish the privilege at that time. I'm here to tell you that you're probably not going to want to carry through on that privilege if your case goes to litigation, because you're probably, if it's been a good investigation, want to rely upon the investigator. You're going to want to get them on the stand and impress the jury with how many people they talked to, how thorough their investigation is, how many questions they asked, how many additional witnesses were revealed to them, and the fact that they sometimes went back to witnesses, and they sometimes went back to the complainant or the employee who was involved with the complaint. Good testimony. Keep in mind, and there are those on this call, and I see one particular name on the list of those who are participating, who have far more experience with juries than I do. But as a paranoid management counsel, I always think that a jury is going to identify more with the plaintiff than with someone in management, because everybody is an employee, we're an employee, or is related to an employee, but not all that many people are going to be related to management or supervision. So keep in mind how the investigator and how the investigation you're directing is going to play to a jury. Make sure that it is careful, it's planned out, it's all inclusive, don't leave a rock unturned. That has to be your role in the investigation. Okay, now before I go into this, I apologize for it. This looks like complete gibberish and rigmarole, but what I have found is that in order for me to understand this process, and in order for me to help a client understand the process, It often helps if I sort of chart out how these investigations ought to do. It starts out with a complaint. The first thing that ought to be done, and I have clients who have taken great exception to this suggestion, is interview the victim. Some believe the witness or the alleged harasser ought to be interviewed first. I think that is not a good idea. When you interview the witness, I would go through what has happened, get the witness to verify at the end of the interview that they have told you everything they know. You don't want to make this a rubber raft type of a situation whereby when you talk to the victim, they give you items 1 through 5. You come back to them and you say, well, we've looked at items 1 through 5. There was no substance to them. And they say, well, what about items 6 through 10? You say, but you didn't tell us about those. And I'll say, well, I'm reasonably sure I did. But in any case, here's 6 through 10. What are you going to do about it? In some situations, we've had the victim write out the allegations that he or she has. What you're trying to do here is to pin the victim down to everything he or she knows about the case. And there are going to be things that the victim will not remember. But get that pinned down to the greatest extent possible. Reaffirm the policy. Hopefully you'll have one in place. And thank the victim for taking part in this whole exercise. Find out who other witnesses to these acts, each and every act might be. And you may need to, after completing the first interview, step back, circle the wagons, find out what you have. And again, you may want to decide that another person more properly should investigate this, or you may determine that the investigation is going to take a different track than you thought it would take. You ought to tell the victim, and here's something where an area where the laws clash, you ought to tell them that you're going to try to keep it confidential, and they ought to too. That is something you ought to tell to the accused. Now, the proviso I added about other laws is that the National Labor Relations Board, under the previous administration, handed down a lot of cases, the most well-known is Lutheran Hospital, in which they said an admonition to an employee to keep the allegations of a complaint against them confidential violates the National Labor Relations Act because it precludes that person from engaging in protected concerted activity, which is basically group activity, even absent a union, in the form of protecting or prohibiting them to go out and get witnesses who may want to testify on their behalf. Nonetheless, I think in this process, you can tell them to keep it confidential as much as possible. I'd be willing to violate the National Labor Relations Act and put a piece of paper on the wall if you are able to stop a conflict within the workplace. That conflict arises at the next level. You need to interview the accused. When you interview them, it's my recommendation, as some of you may have been through 1,000 of these and don't need my advice, but I think you ought to start out with the general. Have you engaged in any conduct which you believe may have constituted sexual harassment? It's going to have to end up at the end of the interview in questions about the particular conduct involved, and you're probably going to have to reveal facts which will lead the accused to conclude who had made the complaint. That's the point at which you impose a no contact rule. And I think you ought to establish that and communicate it as a zero tolerance kind of a rule. And if they violate it, and if you have properly given it, if you've properly documented it, if there's someone else in the room, and I think there should be for most of this, I think you can terminate their employment, and you'd have to terminate their employment. At that point, I think you need to make a decision as the attorney involved as to whether you want to suspend the accused pending the conclusion of the investigation. That's going to depend upon each and every investigation. If it's a small facility, a small workforce, if you only have 10 people in there, you may want to suspend the accused. Now, that may result in an accusation against the accused by everybody involved. The employer wouldn't have suspended him unless they knew that he had done something wrong or she had done something wrong. But I think you need to maintain the workplace, a proper functioning of the workplace in the meantime. So consider it. You can make it with or without pay, but you may need to just separate the parties. Find out those witnesses the accused may want you to talk to. But don't let it end there. Look for independent witnesses, other people who you know were in the workplace, the supervisor, coworkers, others who worked on the machine. You need to search out independent witnesses as well and not necessarily wait for the victim or the accused to give them to you. You need to make a decision in the investigation and keep in mind that your response may be a defense. It may be a defense to liability versus damages. We've talked about those tests. When you interview the accused, nail down whether they were, or the interviews the victim, nail down whether they were aware of your complaint procedure, and if they didn't use it, find out why they didn't use it. Again, you may be engaging in this investigation after a complaint involving tangible damage to the employee has been presented to you. And let me cut back on that to add one other thought. Okay, if it was a situation involving tangible damage to the employee, and if a supervisor has engaged in it, again, your client is going to be held strictly liable. That boat has sailed. Should you just sit on your hands? Should your client sit on their hands? Absolutely not, because it gets back to what I said about juries. Even though liability has been established, a jury is going to have to decide damages. And if you get information about alleged harassment, even if tangible in nature, and you can't escape liability, I still think a thorough investigation and a proper follow-up is going to help you with the jury when it comes to damages. So I would follow through on the investigation and don't just let it sit because the boat of liability has sailed. I think I'd go through it, do the right thing, establish yourself, your client, as an employer that is doing the right thing, and follow through with the investigation. Again, your response is going to be an element when the allegations are made against co-employees. When you find out about it, by golly, your client better react. It better be timely. It better be thorough. And then let me reiterate here, get back to the victim. Don't leave the victim hanging. I don't think, again, I'm being redundant, you need to tell them about exactly what you have done to the accused, to the alleged harasser, but get back to them, thank them for bringing the situation to your attention. Assure them that if anything further happens, it should be brought to you. And you can even remind them at that time that according to company policies and because it's the right thing, you will not tolerate any retaliation against them because of what has been said. And there are going to be situations where the accused may be a very popular person in the workplace, and no one is going to like the fact that the victim brought it forward. You have to follow through on that, and you may have to assert yourself to a greater degree to make sure the victim gets protected from any splashback. And whether that involves a plant meeting, whether it involves further training, or whether it involves conversations with certain victims. Because if you find that a coworker, not victims, but coworkers, if you find a coworker has engaged in retaliation, that is cause for discipline up to and including discharge. The one thing I'll mention about plaintiffs, I was at a seminar when a management lawyer was asked what advice she would give to plaintiffs' attorneys. And she gave, I think, a very simple, straightforward, but highly insightful answer. Get your facts straight. Again, in a huge number of cases in which I respond to complaints with either the State Department of Labor or Nebraska Equal Opportunity Commission or the Equal Employment Opportunity Commission, the complaint will be rife with falsehoods or incorrect statements. And I'm here to tell you it makes a difference when the investigator tries to evaluate who's the credible party. So have your client get the facts straight. Double check them. Don't take what the client gives you unless you absolutely have to at face value. Double check on it. Have your client properly report the harassment. Get a copy of the company harassment policy. Review the reporting procedure. See whether there's a leap over. Document the actions and comments. Have those documented on the front end rather than after a while. Have your client follow up with the company after the investigation has been initiated, after the complaint's made. Have your client keep a journal or a record of what has happened, and have them be aware of changes in the workplace that they think constituted retaliation, retaliatory actions and comments. And I would not be reluctant to bring those to the attention of management as well. The more you put on management's complaint or plate on the front end, the better I think it's for your client. This is a reading list for you. Over the early part of the week, I went back and read a couple of these cases, and it was re-instructive. It was, in other words, it sort of took me back to the basics, and it was a good way to get reacquainted with the law. Read the Ellerth and the Farragher cases first. They're 20 years old. They're still great law. Meritor back in 1986 was when the law in this area really began to change. So I would put that probably on the list after Ellerth and Farragher. On-call, same-sex discrimination, that's where the non-civility code comes into play. You can read that. May want to touch on Vance with respect to what constitutes a supervisor. And I threw this subcase in because it had to do with what sort of tangible action is sufficient to create a supervisory status for the purposes of the various tests. And this case took a step away from the test in Vance because they said that the control over a custodian's work schedule was sufficient to cause a, quote, significant change in benefits as required by Vance. In other words, a tangible action against the employee. So you can look at the Vance case, be aware that in practical terms, there are going to be other situations where the definition of who is a supervisor is going to be expanded. Take a look at Vance and you can decide for your own. That constitutes the conclusion of the seminar. I appreciate your having taken a part in this. Thanks to the Bar Association and everything they did. Thanks to Marilyn for taking her part, the part she has in the planning of it. I hope you found this informative, and please follow up if you have any questions after this. Thank you for your attention.
And thank you, Steve, for presenting this month's Law for Lunch on this very timely and relevant topic. And thank you to those who were able to join us. I did receive one question, which I will make sure to forward on to Steve. Again, if you do have a question that you would like to present to our presenter, feel free to send those to me directly at elizabeth.overmo@sdbar.net. And with that, I hope you have a great rest of your week. Bye-bye.